Thank you for organizing.
Huh, you're welcome, Bruce.
Where's Bruce? There he is.
Here.
All right, so let's get this virtual outreach event, our VOE, underway. We're going to be talking about the Alston case. I hope all of you listened to our little webinar discussion we had last week, and as is our sort of new order, once we do those recorded events, we like to have one of these virtual outreach events as a means of having a little more dynamic interchange with our membership to talk about, this particular case and what it means. And, obviously we all know that the Alston case is a fairly limited decision in its scope, but when you play around with things like Justice Kavanaugh's interesting concurrence, it opens up the door to lots of other discussions. So feel free to ask about whatever. Obviously, we have the panelists who were with us before. Matt, Allison, Tyrone are all with us again today. Unfortunately, I have a conflict and I will vanish into the ether in a few minutes. But, rather than us going over it, although maybe a good opening would be, if Matt, would you mind just giving a 30,000 foot of what exactly the Alston decision says, not what people think it says?
Well, sure. As you said, I think it's a fairly narrow but very important decision. The Supreme Court unanimously said that the full rule of reason applies in this case. And so what it means is essentially any NCAA, well, not any, but most student athlete eligibility rules, and there's an amateurism rule. This one dealt with a limit on the at the national level, the educational benefits that the NCAA had, and the NCAA, of course, as its member schools, had agreed would cap the educational benefits that an individual school could provide. And the district judge's decision was affirmed. It was an injunction, and the court basically said that there cannot be an NCAA rule that is going to limit in-kind educational benefits that member schools could provide. So, for example, microscopes, lab equipment. If a student athlete is a science major, musical instruments, if they were a musician, for example. And the judge also said that it was an antitrust violation for the NCAA to cap the cash value of educational benefits. And I guess this would be, let's say, could be a graduation bonus or cash that would be provided for satisfying academic requirements. Like, let's say you just satisfy the freshman eligibility requirements to move on to a sophomore year, couldn't be capped below, I think it was $5,950. And the court looked at, that's the amount that at least theoretically a student athlete could earn, if that's the right word, for either academic or athletic achievements on the exceptional level under current NCAA rules. So that was upheld. The court said that that was a substantially less restrictive alternative. All 9 justices agreed on that. And then Justice Kavanaugh, in a, shall we say, strongly worded concurrence, suggested that other NCAA student athlete eligibility rules might not survive full rule of reason analysis. So hopefully that's 30,000 feet.
Thanks. I think that sets it up. I think that sets it up nicely. And if anybody has any questions, please use the chat function, and we'll see the question and be able to get you, and then have you unmute yourself, and we can engage in some conversation. Real quickly, Allison, I know we talked about it in our event last week, and one of the things that concerns me is educating your athletes at your school, for example, at Princeton, educating them on what this means, because it seems that there's a lot of potential for misinformation, and how, to the extent you can disclose it, how you're dealing with that educational aspect of what this decision means.
Yeah, I think that's a good question. The timing is interesting though, because, as Matt noted in the beginning, I think most people think this is NIL, name, image, likeness. So there's that confusion. So I think when we're giving education on that, it seems to satisfy a lot of the students. But really what we've been sharing with this on the Alston case is that this is benefits, educational benefits provided by the school. So it's not anything provided by an outside party. It's not provided by boosters or donors or anything like that. It all goes through the school. So that's kind of one big difference between this and name, image, likeness, where you're talking about compensation earned outside of the university and not paid by the university. So that's one thing we've been making really clear with the student athletes. We haven't had too many questions, and maybe it's because it's summer and people really aren't thinking about their educational expenses right now. Thanks, Bobby, for being here. But I think, we'll probably get a few more questions in the fall. I think that the NCAA, I mean, as I think everybody knows, the NCAA is a membership association. So the rules and the guidelines and all of that are created by the member schools and conferences. And I know conversations are being had now at looking at what exactly are some parameters or guidelines to define what educational expenses are, because I know there's all kinds of questions out there for, what if it's a private jet flight to go on a research trip, or, something like that you can call academic. So I think there'll be some guidelines. I also think there'll be some NCAA legislation, and I don't know if this is confirmed, but my assumption is there'll be some NCAA legislation that opens this up to all student athletes and not just basketball and football, so that we're not going to have the same types of equity issues or concerns that you're providing all of these great benefits to just a couple of teams on your campus. So those are the conversations that we've been having mostly on campus about this, and then everything else with NIL has exploded. So I think people are kind of not thinking as much about it as they will in the fall.
Actually, if I can follow up on Allison's point there, I think it's, just for background for those who may not be as familiar with the Alston decision, the class actually was by Division I men's and women's basketball players, and you had FBS football players. So, one of the things that we have as a baseline is, the applicability of that outside of that group, right? It would be really inconvenient for institutions to have to define educational benefits for certain sports one way and then other sports another way. There's no practicality with it, and I don't think there's going to be a lot of that coming into play. But there is, some background here. I think it certainly within conferences would, think people have considered educational benefits. Laptops. Is it the super laptop? Is it, just having a standard laptop, what have you, that most of us may have had in college experience? And there's going to be some reasonableness that has to be intertwined in the rules. But I think right now we're in a really tricky situation is why there's not rules. Whenever you have something that's overruled by a court, I think that intersection between having when that rule has been stricken and when you actually have something that's put in place becomes really tricky. And there's some trickiness even about the schools conferring with each other about that, because of what's stricken down here. So I think there's going to be a lot of good decisions that have to be made with some solid basis of tying the benefits to the educational program, because that's going to have some other effects that may have VOE ramifications, which is not something that was really talked about because it's not an issue in this case. But how does the Department of Education look about how those benefits may go beyond what we're doing for the cost of what someone's doing for school?
And just to follow up on that is the Supreme Court made clear that the NCAA could go back to the judge, and you're going to have to get apparently the district judge's approval, at least in the first instance, as to is this a legitimate educational expense. So for example, let's say a football or basketball player or some other student athlete lives 5 miles from campus. Might be one thing to say, hey, here's a bus pass, but another to say, well, we'll send a limousine to pick you up every day. And, it's kind of interesting because usually, having been an antitrust lawyer for about 30 plus years now, it's either an all up or down. It's a reasonable restraint and it's lawful, or it's unreasonable and illegal. But here, the court's going to be retaining jurisdiction. And, I can see, someone's going to push the limit somehow, and they're going to have to go back and get some clarification. And that's rather unusual I mean, kind of going back to when district judge in Washington was overseeing the Bell system. Not quite to that level, but that's quite unusual that you have one judge kind of overseeing and determining what's competitive and what's not. But that's what we've got for now.
So we have a few questions in the chat. Bob Wallace had one, and I'll get to you in a minute, Joseph. But Bob's question, I think we can address quickly about the Ivy Leagues not having athletic scholarships. So how does this apply? And it still applies to the Ivy League just because these are educational expenses that can be provided by the institution. Some of it is what's provided to all students, and that's pretty much how it's going to happen on the Ivy League campuses. You know, if these are educational benefits that are being provided, there is need-based aid, which can then also include some of these educational expenses that may be beyond what was normally included in that as well. Again, for us, it's going to be mostly what's available to all students.
You know, one thing it seems to suggest that Alston suggests that could be subject to antitrust challenge, because as I understand the ruling, it says the NCAA and multiple conferences cannot do this. And since this is Division III, that would be multiple conferences. I guess the first question is, do they collectively have what's known as monopsony power, which, you know, district court found the NCAA did in at least the sports of football and men's and women's Division I basketball. But I think that's one of the issues, is that there's nothing that would preclude an antitrust challenge to just that, saying that the Division III schools are agreeing among themselves not to offer any athletics related financial aid, and that in and of itself violates antitrust law, or at least there's a substantially less restrictive alternative that they'll try to push.
Well, the Ivy League is Division I, so we'll still be
Okay.
all the same rules as the rest of Division I. My sense is that because we can provide things, and I should probably clarify a little bit what I said, we can provide things like the unlimited meals that are available to student athletes, all of those types of things we're permitted to provide. I think often when something like this opens, the league has a conversation about what does this mean and what should this look like for us. I'm guessing that, kind of as you note, Matt, that with the fear of looking like we're restraining any kind of free market, that there would be the permission for the schools to provide these educational expenses such as they are. I don't think they'd be quite as lavish as maybe at some other schools, but I do think that there'll be some opportunities there. But again, it's provided by the institution, so it would have to be kind of within budgets and all of that. But again, we'll have to see how that goes. Like I said, everybody's pretty much focused on NIL right now, so it's almost like this has taken a back seat, but I do think it'll pop up again as we get closer to the start of the academic year. Joseph had a question. Joseph Goldhammer, do you want to ask your question, or do you want me to read it for you?
You can go ahead and read it.
Oh, okay. All right, so he says, isn't the ultimate solution to the uncertainties created by the Alston decision and the availability of NIL income to athletes ultimately the unionization of college athletes? The employer would be the NCAA and conferences. It would avoid perpetual antitrust litigation and would give themselves a voice. Now, Matt, I know you talked about this briefly on the podcast. Do you want to take first stab at it?
Well, I think what Joseph is getting at is kind of looking at the professional model, where at the major league professional team sport athletes have chosen to unionize and collectively bargain. And then you have both the statutory and non-statutory labor exemption that precludes an antitrust challenge. And that's one of the problems in this case here. There was an effort to unionize Northwestern football players. I guess the regional, I don't know what the correct title would be here. The person who oversaw the NLRB Chicago office thought that they were employees, they should be permitted to unionize. But the NLRB took a different approach. They said, well, this is just one sport at one school. Northwestern is the only private university in the Big Ten. And the NLRB said, well, that would be unworkable. You got to have, uniform rules, and you've got 13 other schools in the Big Ten. It might be collectively bargained different rules if the football players did it. So there'd have to be a pretty significant change at the federal level. Congress would have to determine that at least student athletes at private universities and college could unionize. And the problem is there's just as many, if not more, students at public universities and colleges. And my understanding is whether they can unionize is dependent upon state law. After the efforts to unionize the Northwestern football players, a number of states, Ohio and Michigan in particular, enacted legislation that said intercollegiate athletes in their respective states are not employees and they can't unionize.
Yeah.
Can I follow up with that? So the NLRB decision in the Northwestern University case only applies if you conclude that the individual institutions are the sole employer. In other words, in professional sports, there are NLRB decisions which clearly hold that both the individual teams and the leagues are joint employers. And so it is a labor law question whether the NLRB can consider the NCAA and the conferences as joint employers, and they are private employers. So they can be collectively bargained with under the National Labor Relations Act. So the petition or the recognition would come from the NCAA or the conferences or both. It would not come from public employers, and those state laws would have no applicability at all. And then the collective bargaining would occur between the union or unions, which represent various categories of student athletes in various kinds of collective bargaining agreements, and their conferences and the NCAA. And the individual institutions would not be a part of that unless they were private or wanted to, in which case they could. But the public institutions would probably not be involved in that collective bargaining at all. But the subject of these antitrust lawsuits is almost always the NCAA. So they would be the employer. They would negotiate with some legitimate unions representing the interests of the athletes, and we would avoid all of these litigation and all of the going back to court all the time, which is an unworkable system. And as Matt pointed out, it's just every time you had a question, you'd go to court. Well, that's not a workable system. You've got to have a system where the parties can negotiate solutions that are exempt from antitrust law. And so that's my view of it.
It's an interesting point, but I do think there's a little bit of when we go to the making student athletes employment route, we're robbing Peter to pay Paul, because you just raised a whole host of employment issues that are going to come up now. I mean, even if we accept the joint employer route, first of all, who's the collective bargaining unit? Is it going to be those who are in full scholarship, those who are in equivalency sports that actually have kind of little separate issues because they're partially on financial aid that's need-based and partially funded by the school? How are we going to actually divide this by, you're obviously by conference level and things like that? There's all kinds of things. And that's before we get to the issue of you're now applying employment law. So now Title VII comes into play. Now we have workers' comp issues that come into play. And we have to figure out how we're going to actually regulate that when the NCAA does not really have kind of the tentacles to have those underground, how are people being treated day to day? How are, what are the quote working conditions at each school, that type of thing. So it's interesting in the effect that would have from obviously a labor exemption for antitrust, but it also raises a whole host of employment issues that haven't been really talked about.
Yeah, I agree completely. I mean, and while we would love to get away from the constant litigation, I don't think the NCAA or the conferences are set up as employers. I mean, right now they're voluntary memberships and the schools pay dues to belong. And so, yes, there are rules set by the conference or by the NCAA that govern competition, but it's not really set up where the schools are or the conferences are doing any of the recruiting or the hiring or any of the aid packaging or any of that. There's just not that same kind of relationship that an employer would have. So in order to be employers, I mean, I think the closest thing you could find to an employer is the school, but then things would have to change a little bit with that as well, and all of the pieces that Tyrone talked about too. But I think we'd have to really change the whole model in order for the NCAA or the conferences to be considered employers of student athletes, I think, at this point.
Yeah, and I guess the other question I would have is, it makes sense, you know, let's look at the NFL, that the players union negotiates with, you know, representatives of the clubs rather than each individual club. But there you've got not only the league, but its component parts. Each of the clubs are private. I'm not a labor law expert, but does that same principle still apply? Like, let's say the Big Ten, it's probably structured as a private entity, but 13 of its 14 members are public schools. I mean, does labor law provide a clear solution to that?
Yeah. I mean, there are cases, for example, involving referees working for, I think, the Big East when that was a conference. And the Big East contended that they were mostly composed of public institutions. And the National Labor Relations Board said, but you're not the public institutions. You're a separate entity created by those institutions. You're a private organization, and those referees can collectively bargain. For example, in the private sector, for example, the NFL does not set up to hire players. They don't hire players, the clubs hire players. But the NFL sets the rules. And so they are a joint employer because they exercise joint control and over many aspects of the employment. And the NCAA exercises control over many aspects of the employment. Therefore, the collective bargaining would occur not with the individual public institutions, but with the NCAA. And I don't see any reason why, thinking outside the box, that you couldn't have collective bargaining with one of potentially or two of the three joint employers, and exclude from that bargaining public institutions which might hire the players. But in many instances, joint employers don't hire employees. The other joint employer does that. And as far as collective bargaining units are concerned, and what are appropriate collective bargaining units, that's what the NLRB was set up to do in 1935. And they've been doing it ever since then. And they're in many complicated industries, like the healthcare industry. They have established rules for bargaining units, and they would do the same thing here.
Well, I think one last comment I'll make on this, and we can move on. I see there's another question, but the referees situation is different because they are actually hired by the conference. They do bring in, they have the deals with the various referee groups. So it is slightly different. I think it's interesting. I mean, it's definitely an interesting perspective to look at. I think those of us who are in college athletics would look to avoid creating an employer-employee relationship, because that would really fundamentally change what we do. But that's another story for another day, and we will have that conversation. But I do appreciate, Joseph. I think that was interesting.
And thank you for letting me comment. Thank you for
Sure.
allowing me to comment.
Of course, of course. So Patrick Stubblefield has a question. He says, since the NCAA already permitted full cost of attendance scholarships, is it not concerning that there are educational expenses that aren't covered under the cost of attendance umbrella? Financial aid, federal, state, and institutional, is often capped at the cost of attendance. So wouldn't that suggest there are educational expenses to attend college that a normal student will have to pay for out of pocket? Does this case highlight a bigger problem in higher education? For me, I think, cost of attendance, because it varies by school, and often it's set by, the how much it costs to travel to the area. And it might be different if it's a, very remote school versus an urban school. And there's so many different pieces that go into cost of attendance. I can see there being various expenses for students or student athletes that aren't necessarily covered in the cost of attendance. What I think will be interesting with this is, we have this special assistance fund that and athlete opportunity fund that allows the payment of quite a few expenses that student athletes run into that aren't necessarily included in their cost of attendance. I think this will move some of those expenses out, and the school will be able to just cover them, things like laptops or things like other educational expenses, and then keep that fund for other types of costs or expenses that student athletes might have that are not necessarily educational in nature. But I don't know if either of you have anything you want to say about that, Tyrone, Matt?
No, I mean, I think it's an interesting point that, to the point what is a problem in higher education. I don't know what to call it a problem, but it probably is something that should have been re-examined about how do you define what educational expenses are? Because we've had that's been the NCAA manual for years. And I don't know if there's really been a lot of, unless, in a handful of cases where it's been brought up by a student athlete for something not being covered. I don't really think we've had a lot of debate about kind of refining what that is. So I think it's something that we, probably should have looked at before now. But I don't know. I don't know if I would say it rise to a bigger problem. I think obviously the big issue is going to be what happens with athletic grant aids going forward. Is our athletic grant aids going to be what we understand them to be now, which is covering full cost of attendance, or are they going to be something else? That's I think the larger issue.
Right. And this is all still, up to the institution, what they want to provide, because not every school provides the full cost of attendance amount. And I'm guessing not every school provide up to the top of whatever the educational expenses are, because everybody has budgets. So there are going to be some schools that can provide a lot more than other schools. So I do think we'll see some variety there as well, just like we've seen with the cost of attendance. And that has seemed to shake itself out, and kind of schools and conferences know where they fall in that area. And so I think this will probably be fairly similar. Since you bring that up, Tyrone, I think this will probably follow along in that same general direction, looking at, how are we going to spend our budget that we do have versus let's do everything and then ignore other things that we might have to spend the money on. Are there any other questions out there? Anything that either of you guys want to bring up?
Allison, I have a question for you. As someone who's been in college athletics administration for a while, and of course we're still in the pandemic, we're coming out of it, and everyone took a pretty good cut. How likely do you see it that individual schools are going to start offering more, particularly to their student athletes who have full cost of attendance scholarships? Because again, you can't just do it for, male athletes. You've got to do it for an equivalent, make sure you've got your Title IX gender equity. And, I looked at it and said, you got to be careful within the football team. If you're going to do it for one, you got to do it across the board, because that's just going to exacerbate some of the, I don't call them inequities, but it's going to be different. Not everyone's going to have the six-figure NIL rights income. How do you see, or what sort of factors might schools consider in whether they're going to individually do that? Certainly competitive factors is going to be one thing, but economic, and how realistic do you think it's going to be that individual schools are going to start offering substantially more than the value of what student athletes are getting now?
Yeah, it's interesting. I think there's gonna be a lot of conversations at the local level. I think it's very much like what we talked about when cost of attendance was being voted in. I mean, this was something, cost of attendance, when I was on staff at the NCAA a very long time ago, we first started talking about that, and couldn't we provide this, and wouldn't this be great? And we just looked at the variety in what could be provided in cost of attendance, legally be provided in federal limits, and just said we can't figure all this out. And I think because the NCAA was a different place right at that point, right now we're in the place where there are quite a few rules still, but the focus behind the rules isn't, I can't afford to do this, so you shouldn't be able to do it either. It's, let's look at all the things that are permissible, and then it's up to each school and or conference to decide what it is that they can afford and what matches their philosophy with what they're going to provide to student athletes. And so that's how cost of attendance was able to happen, and happened fairly seamlessly. I think there was a little bit of maneuvering and adjustment of cost of attendance at various schools, because I think a lot of schools keep it down a lot because then you're in one of those more affordable schools and everybody wants to be ranked, you know, the top most affordable program in the country. And I think the two things are at odds with each other. So I think there's some changing there, but for the most part, conferences looked at, you know, what they would provide and what the schools thought was appropriate to be able to provide. And I think a lot of individual schools looked and said, this is what our budget is. We can afford to give these two teams cost of attendance, but we can't do any others. And they just do an economic analysis of it and a competitive analysis. You know, are we going to be able to be competitive in this sport if we don't provide either the full cost of attendance or now some of these educational benefits? So I think it's going to be really considered on a case-by-case basis as to, you know, what's your philosophy and what you can afford. There's, as Tyrone mentioned, there has to be a conversation of what exactly educational expenses are. I think everybody's comfortable with the idea that if somebody really needs a laptop and they can't afford it, then that's something that you can be able to provide them. If they're looking to take some sort of field trip and there is a personal expense component of that that's not included in financial aid, you know, that type of thing. I think those are things that are already covered in other ways now that can be covered under the educational expenses piece of it. But then when you get into much bigger and bolder strokes, I think there's going to have to be some conversation about what that is and what actually is an educational expense, how tangentially connected does it have to be or can it be before it kind of falls off the educational expenses piece. And I think that's something that just has to be determined. I don't know if there's going to be the appetite to have that conversation with the whole antitrust potential. But I do think that NCAA still has to talk about, you know, if there are rules in place, the rules have to be clear. And if you're going to have that rule, it needs to be defined for the membership so that it isn't this, somebody did this and now we have to go back and enforcement is looking at this and is this a violation and a determination. So there's going to be a lot happening in the near future in terms of what this all means. And I think we're all just trying to figure it out on our own end as well. You know, what makes sense for our schools. You know, we still have students, right? And so the educational component part of it, yes, you know, we got NIL on the other side of things too, as you mentioned, and you know, how much time is going to be spent on figuring out how much money the student athletes can get in various areas and what really is our purview, what really is that we should be spending the time on and looking at. Bob, you want to jump in? Wallace? Or you want me to read it?
Hey, Bob, you're on mute still.
No, I don't want to jump. You can just read my question. I'm just wondering whether, well, I guess I'll ask it. So Kavanaugh invited challenges. And my question is, what do you think is next? And what I've always argued is that they keep trying to put their finger in the dike, the NCAA, to fix problems, instead of really looking at the total NCAA picture and saying, we really need to change the way we're doing business globally because the world is much different than it was in 1950. So I'm just wondering, what do you guys see that happening and what's next?
Yeah.
Well, I think we're going to see a challenge to, you know, current NCAA rules limiting schools from providing, you know, the non-educational related benefits. And there'll probably be a suit filed somewhere other than the Ninth Circuit because both O'Bannon and Alston upheld that. You know, they basically said, made it clear that just talking about the, you know, what is the language in O'Bannon said, they can limit educational, you know, economic benefits untethered to education. And there was an effort to have that reconsidered by both the district court and the Alston Ninth Circuit, and that was rejected. And the Supreme Court made it pretty clear they were just dealing with that aspect. So probably within a year from now, I wouldn't be surprised to see, you know, challenge brought to the, you know, the NCAA's, you know, amateurism rules, but probably some other circuit other than the Ninth Circuit.
I would agree with that. That's easily, I think, up next, and that's the big one to see what happens, because that's a financial game changer for the whole model when it comes up as to whether, and the question now that we have autonomy with the Power 5 conferences, and now that we have obviously this enhancement of educational benefits, whether that has influenced the thinking on that so much. To the point about a revamp, I think that's a great point. Like one of the theories that I have is that I don't know that this case completely destroys the NCAA's credibility when it comes to using eligibility rules or certain limitation eligibility rules and getting deference from courts. That I think, when we talk about things like they've been successful in the past, such as the year of residence rule, and things that have been litigated in other circuits, that there's still some deference for that. It's when you have things that have this hardcore, clear financial implication that does not seem to be the appetite of the courts. And I think that's where this conversation has to start, is what makes sense now for a new financial model. Maybe for competitive aspects, maybe the scholarship limitations make some sense, maybe they don't. Maybe the way we actually have obviously the transfer program is different now than it used to be too. But when we look at the financial model, like just starting top down, what makes sense with that? I think that's going to be, and obviously you're worried about the member institutions who are going to be funding these scholarships, and how does that work? Because not every school is funded the same way. Not every school has $1 billion endowment. But what would that look like across the board?
And I think what the question that's also raised is, where does financial aid and federal financial aid limits, where do those come into play? And how much of this, if it's still education or if it's still part of this amateur enterprise that's part of the university system, where does that come in? And how much can schools provide outside of what would be the federal cost of attendance without there being some kind of overstepping there? And so I think that's something that's going to have to be looked at. I think that Bob, you mentioned, since the 1950s were very different. I mean, I think if you look at the history of the NCAA over the years, I mean, it's unrecognizable now from where it was, even 20 years ago and before. So I think if you look at how the NCAA has progressed over the years, it's really an anomaly. It's this membership-based association that everybody has an interest in, and there's a lot of different stakeholders and looking at various ways to be connected, or those who are connected. And then there's kind of the way things were set up. And so we're still in some ways working off the original model. And every time there's been some sort of crisis or some kind of court situation or whatever that comes up, the association kind of looks inside and looks at how things are done and revamps, and things change. So you went from, all schools competing to Division 1, 2, and 3, and then Division 1 further subdivided. We have the autonomy more recently than that. We have all kinds of changes, including the cost of attendance now that we have that would never have seemed possible 20 years ago or even further beyond that. There's been so many different changes to the model that it is unrecognizable, and it's still tied to this notion of amateurism and of institutional control. And I think those two pieces are the keystones and where things all set up. So if there is going to be some revamp, I think there could be these, quote unquote minor changes like cost of attendance, like we look at educational expenses, like we look at NIL, all of that. But I think if you keep pushing beyond, then you start getting into what is the NCAA overall. And so does the association continue to look back inside and retool and revamp and make those changes? I think, for now, at least, things continue to work that way. I think the interesting part is where we are now, it's so public. Changes used to be made inside the rooms, and you had that convention, and you could take a year to get your legislation through and build your support and everything. And now everything is instantaneous, and 1,000+ member organization doesn't really move on a dime. So how do we figure out what needs to happen more quickly, knowing that whatever decisions are made are probably going to be challenged and need to be tweaked, and nothing is ever perfect when it first happens. But how can we then satisfy the needs of our members and needs of the student athletes and still maintain what those of us in the system think of as the most important parts of it?
Well, I'm just going to push back a little bit on Allison on that, saying that you may have changed since the 1950s, but not willingly. It's always has been where you've been dragged across the lines of change. So that's one problem. And you say that all these different constituencies, the only constituency that hasn't had a seat at the table are the student athletes. And that's the problem. And so your question, what is the NCAA? What it is now is different than what it is in 1950, and it needs to change. We keep trying to fix it without dealing with the overall structure of what college athletics is in 2020 and beyond.
But the
Well,
student.
Bob, there's, I think one other, we've mentioned antitrust law and labor law, but there's one other really big area of federal law that might come into play here, and that would be federal tax law. The IRS has said that student, athletic scholarships, not subject to federal income tax, but based on your argument that, hey, this isn't the 1950s anymore, it's now 2021, I could see the IRS stepping in and saying, guess what? This, whether it's characterized as an employment relationship, it's, a quid pro quo, there's commercial activity, and student athletes could be much worse off if the value of a full cost of attendance scholarship is subject to federal income tax. So that's the other thing that'll be really interesting to see as this evolves and as some student athletes start getting six figures NIL rights income. I understand that's going to be taxable, but then they might just go back and say, everything you're getting, all of these economic benefits. So that's another important matter. I'm not a tax expert, but I can see that happening at some point.
Agreed.
I could too, but that's the whole discussion, is that there's a whole bunch of things that need to be discussed, and we're not discussing them. We're just trying to deal with individual problems as they come along. And we've proven over the last 20 years that doesn't work.
Well, Steve Ross and I did a good law review article on this, talking about case by case antitrust litigation doesn't work. You need some sort of a federal commission that would come up with, all things considered, here's what it proposes. And then if it's voluntarily adopted by the NCAA, various NCAA divisions, conferences, schools, then that would have protection from, antitrust liability. So it wouldn't be imposed. It's kind of a different approach. But, I agree. It's got to be looked at globally. But currently, we're going to have a lot of case by case antitrust litigation. And as Joseph pointed out, well, maybe there's, some sort of global solution is the way to go, whether it's labor law or whatever. Because otherwise we'll be in the same place 50 years from now.
I think there's the other part of it too, Matt, and I agree with what you've said completely, is that you've got a very wide variety and disparity when it comes to student athletes in the various sports. You've got, some very high profile sports that are bringing in money, and then you have a whole lot of other sports that are not. And so talking to the student athletes, there are student athlete representatives nationally on all the various NCAA committees and councils. The conferences are bringing in student athletes or have brought in student athletes to their councils as well. Perspective is going to be different depending on who you ask and what it is that they're looking for. And take NIL out of it, because I think there's some very unique differences in that area. But in all of the things that we're talking about in terms of Alston and related connections there, I think that you have a pretty broad audience here of student athletes, and we're hearing their input on the various proposals that come in, on the various discussions. And again, it's going to change based on what sport they play or played and how engaged they are. So I do think there's a lot of conversation that needs to be had. I just think it's not as easy to paint it with a broad brush and say it's broken for everybody, because I think there are a lot of sports who are getting a lot of support in ways that they wouldn't if things changed dramatically. And that's what worries some of us, especially Ivy League, and you're an Ivy Leaguer. We have 38 sports at Princeton. Can we keep all 38 sports if we have to, reallocate the money to support in different ways? And we're a little different because we have so many, and our budget thankfully is okay. But looking at some other schools, are there a lot more sports that are dropped because of financial issues, because of things that need to be provided? So I think it's something we need to really look at, so that we don't unintentionally harm a big section of our student athlete population while we're trying to help others.
Though I wish Allison that Princeton would show some mercy on my poor Dartmouth more often. But
I should have known the green.
I do think that that's the NIL point. The one kind of caveat we'll say here that I think is interesting, that everyone thought when NIL was coming out, all right, you're going to have these 7-figure deals coming out the door and just flying all over the place. And then you hear at schools like Jackson State that 5 kids were actually getting, contracted with certain local entities down there, or some social media deals, which lets you know that, sometimes this may be a little bit bigger than a lot of us thought. And I think it raises an interesting question about how, just because we're in a new landscape, is we've only been 7 days in of NIL, as far as that being something that student athletes can do, whether that actually is being viewed as more of a cure now that that cap's been unlifted and you have third-party compensation to student athletes. Because I still retain the belief that there's a big difference whenever we talk about student athlete compensation. I always say you got to say from whom, because there's a huge difference. I think even within the courts, and it's kind of implicit in some of the opinions that we see now, when that comes from third parties versus the actual institutions themselves. That's still, I don't know that even factoring in the unanimous decision we had here in Alston, I don't know that we've crossed that with the, well, maybe Kavanaugh has, but I don't know that we've crossed that with all the justices yet. So I think that's something to keep in mind and actually monitor as we have going forward, like how successful it is, how it's able to be managed by the compliance officers of different schools, what type of fights we actually have as far as schools saying, well, your school's being more restricted than we have under the state laws that now have this, actually on the books or by executive order, whatever it may be. I think we actually we're in a very interesting evaluation period right now.
Yeah, that's a good point. So here's something I read in ESPN.com yesterday. There's a University of Miami alumnus who apparently, promotes mixed martial arts and has said, okay, for this coming year, every member of the football team is going to get $500 or $540 to promote, my MIA enterprise. And said, I don't know if I'm going to be able to do it going forward, but then wants to start a nonprofit foundation and is trying to encourage other supporters of the university to contribute to it. So there will be a fund of money to bring back the U football program. And apparently, does it violate Florida law? It's like, well, this entity itself has not ever supported University of Miami athletics because it is new, even though those contributing to it would be, which in my mind raises some really, really interesting questions, which you kind of hit on, Tyrone. It's kind of, who's it coming from? It's like, well, a separate entity, but it's set up of boosters, alumni, not directly from the university. So there's going to be some interesting questions. And, maybe it's not the worst thing Congress didn't act by July 1st. They can kind of see what's going on out there. And maybe Congress will say, all right, we kind of see what's out there. Here's what we think it ought to be. And hopefully we will get that uniformity sooner rather than later, at least as to NIL rights.
Yeah, I mean, you're right. Look, if you look at just the various state laws that are on the book now, even those that aren't fully implemented yet or fully effective, they're all different. And some allow for profit sharing. Does that mean losses too? We don't know. Some allow for, what you talked about, the Florida law, does not allow any boosters to hire or pay student athletes, but that's why he's setting up this entity that's separate. New Jersey law, which is not effective yet, it's supposed to be 2025, but it's moving really quickly now to catch up and be sometime this summer. There's whole categories of deals that students can't participate, student athletes can't participate in by state law. There's requirements for what prospective student athletes can or can't do versus current student athletes. So you're right. I mean, it is crazy depending on what state you're in, what those laws are and if they're effective yet or when they become effective. And then how does that work hand in hand with university policies? Some universities say it's fine for student athletes to use their marks when they're selling their NIL. Others are saying, no, you can't have a picture of yourself in your uniform and then get out there and promote this business. And then what happens if we're a Nike school and you want to promote Adidas? I mean, there's so many different pieces of this that those of us who even had our policies drafted are still continuing to hone them and trying to, I think you're almost trying to be more restrictive at first because you can't ever get the genie back in the bottle, but it's always good if you can open things up as you go. But it's tough just not knowing what it is that's out there and what the school next door is doing. The Ivy League, as a conference, knowing how those conversations were happening, was very careful not to make things too restrictive from an Ivy League perspective because of the various state laws that are in play in all of the member institutions. And I think other conferences are looking at this the same way. So there's a lot to sort out here.
Here's a question I have that I was asked 25 years ago when I was teaching down in Houston. So it was a family law lawyer who contacted me and said, I represent a woman and the father of her newborn child is a Texas A&M University football player. And I'd like to know is the value of his athletic scholarship something that can be considered for purposes of determining child support? And I said, well, that's a really good question. I said, if you look at the NCAA rules, it's not, it's not taxable. It's not considered to be pay for play. So that's another area. I mean, once you get more money involved, there's more areas of law, more interesting legal issues. She never called me back and let me know, but it was like quite an interesting interesting issue if anyone knows the answer.
I'd say 25 years ago, he wasn't getting anything in hand. It was all going right to school. So it was his housing and his meal and his tuition. So I don't know, and it's not technically income. So my guess is no. I think now if you look at things and say if they're getting a cost of attendance check, it's still not technically income, but that they're getting money, right, to support themselves. So I think it'd be definitely an interesting question to be asked now. I think, you'd kind of run the gamut from, no, it's not income to, well, if they're getting cash for whatever the purpose is, does that still count in terms of what they're able to afford with child support? And I don't know that area of the law super well, but if anybody else does. But Tyrone, thoughts?
Yeah, and you're taking me back to what's the section 1 of the tax code. Was it income is income from whatever source derived unless there's some exemption to it. And then the question is, like, is this exempt from being considered income? And I think the answer, as you just said, obviously with the funds that are going straight to the school, scholarship, room and board, that type of thing, that I think is pretty clear. I think there's a high likelihood that the other portion, to extent, because it would be hard to imagine something that is exempt from being recognized as income from federal or state tax treatment. So you're not paying tax. Well, I guess Texas, you're not paying state tax anyway, but it's hard to see that being recognized for purposes of income for some calculation of child support.
All right, we're getting close to time. We have time for another question if anybody has one on any of the topics we've discussed, or
Or even a comment if anyone has one.
It's a very quiet group today.
I know one of my casebook co-authors, Tim Davis, is on. It's like, well, we got some revision to do for our next edition. Might have to add a few other areas of law and things. There's certainly going to be no shortage of interesting exam questions to ask our students going forward.
That is true. I'll tell you, we have our compliance officer creates a video every year and our coaches are part of it. And it's kind of an entertaining way to talk about the rules that she meets with all the teams. And she's got to do a full revamp this year. So I'm glad we have at least a month or two or a month, actually, that's it, till she has to get it out there.
Hey, Matt, I got a question and a comment. My question is, your optimism is so positive about what Congress is going to do. Can you please share what you're drinking? And 2 is, I thought fringe benefits were not taxable. Isn't that come up lately?
Well,
I'm kidding on both.
Hopeful rather than optimistic on it. And it's been a long time since I took federal income tax. So, get to get someone more knowledgeable than me to answer that question.
Right. I was referring to our 45th. He doesn't think any fringes are taxable.
Yes. Well, Patrick asked, the former soccer student athlete, should I be concerned that the market in the Alston case only included football and basketball? And yes, for now, it only applies to football and basketball. But I think I might have mentioned earlier, I think I see that changing. I mean, I can't imagine how the NCAA as an association is going to have it where there's very different rules for one or two types of sport than from the other. So I expect there'll be some conversation and some expansion of that rule to include all the sports. I haven't heard any final thing about that yet, but that's my guess. I think it makes sense. But yes, for now, only football and basketball. NIL, however, applies to everybody. And Barstool Sports is reaching out to every student athlete out there to be a representative for them. So they're all making some money, or at least getting a free t-shirt. All right.
Is that taxable, the value of the t-shirt? Probably
No.
is, huh?
Is that nominal? Depends how good the t-shirt is, I guess, right?
Yeah, I mean,
Really soft. Yeah, it's interesting. The questions that are coming up are things that we never thought we'd be dealing with. And it's, it keeps things fresh, right? And it's great for the students. I love that they're having these opportunities, and a lot of social media, a lot of influencer type opportunities that we're seeing, much more so than some of the out and out sponsorship deals that we've seen at like Miami and some of the other schools. But I think it gives the student athletes the chance to do some of the things that they have been doing for years and meeting exceptions for. Student athletes, can create their own company, write a fashion line, write a book, develop music, all of these types of things that before they weren't able to use their name in promoting. They weren't allowed to have any connection between themselves as a musician and themselves as a student athlete. And now that barrier is down. And I think that's, to me, what's the most exciting part about this is the opportunity that these students have to do the things that they've already been doing or wanting to do in a way that other students can capitalize on, and they can have even more a benefit potentially because of their reputation as student athletes. So interesting. It's a lot of work, but I think ultimately it's going to be good for the students. We just got to figure out how it all works. All right. Well, I don't see any other questions, but we appreciate everybody's joining us today, and thanks so much for your time. And if you're not a member of SLA, please join. We'd love to have you. And if you are, we're grateful for your membership and your involvement, and look forward to seeing you again on another one of these very soon. Oh, and next week, Tuesday, Sports Short with Scott Beerby, who's General Counsel of the NCAA. So Bobby's going to have some really good questions for him. So definitely tune into that. I think that'll be worth your time. All right. Thanks, everybody. See you next time.
Good job.
Thank you.
I liked it. I enjoyed it.
the third part of our series, this ended up, we did the one, and then I'm trying to think, I've done so many of these. Is this the second one, or this was just the second part of our one? We did.
This is, yeah.
Yeah, because the other one was the past presidents one, I think, right?
Yeah.
Yeah, it's confusing with that. That's well, I tell you, I think Allison appointed co-chairs for the conference committee. There's going to be all kinds of proposed topics for next year. It's like, it'd be interesting to go back, compare 10 years ago, then 5 years, and then next year, and just kind of see some of the stuff. You'd be like, who would have known?
Yeah.
Well, I think about when I first joined, and I was asking, I think Craig Fennick was the chair, and I said, is there anything we can do with college athletics? We really don't do much with college. And then we'd have like that one session of the breakout or the current NCAA issues. And then we were able to get the concurrent session after the luncheon, and we were able to do something with NCAA issues or whatever the current topic. Conference realignment might have been the first one when that all went crazy the first time around. And now, I mean, we look at the sessions we had this year, and we have like 4 or 5 different panels on college athletics and related issues. So
yeah,
I think having Woody and Naima as co-chairs is not a bad idea.
Well, yeah, and that's, if you look at this, is kind of coming full circle, because it used to be just major league professional team sports topics. But if we're moving to more of this professionalized model, which I hope we're not, it's kind of the same thing there. And one thing I was going to ask you, Allison, I forgot to, though, is say, do you see this stimulating another round of conference realignment with revenue sharing, where some schools look at it and say, geez, we really want to be at this level, or we're going to have to drop down. I wonder if it's going to do that in a year or two, depending upon which schools want to do it. I can't see individual conferences putting caps on it, what their schools can do, because you got to consider, like Big Ten's got to consider what's the SEC, ACC doing. I mean, there's just going to be, who knows? It's gonna, your 2 years starting off, it might look totally different when you're passing the torch in 2023.
I think it will. I mean, it's already different even than earlier this year. I mean, things are just exploding. So it's very interesting. Everything moves a lot faster now than it used to, I think, across the board. So
yeah, that's well, I guess done for now.
Thank you, guys.
That's, uh,
Appreciate you
thanks,
taking the
Melissa.
time. We were up to 40, so that was good for,
Yeah.
especially for
Yeah, the
2 in
middle.
the afternoon. So
Yeah. on a
right,
Wednesday,
middle of the
good
day, and
Wednesday.
think of me while I'm in Tokyo, sitting in my hotel room.
I would
But-
love
Can't
to be in
go?
Tokyo sitting in a
Me
hotel
too.
room.
I
Yes.
love Tokyo.
Well, we do get to go to the venues.
Okay,
So
I
the
was gonna
first
ask.
14 days, yeah, it's, in the hotel, we're not able to go out to restaurants, bars. It was funny. They said, download the Uber Eats app because you can't download it there. If you get tired of the hotel food. We don't know if we're going to have meals in our room or down in the, I don't know, lobby area. It looks like a nice hotel. So it's there where there's arbitrations, that building, and the competitions we will be able to go to. But I think we're going to get an app and have to download or whatever. But we can't go out and sightsee or, I'm like, gosh, I've got to get an adapter, for my computer to plug in. And I'm going, if they're sold out at the airport, I'm in trouble. I have to go over there and say, hey, can I go down the street to wherever and get one?
Yeah. Do they have Amazon?
I don't know.
Yeah.
Well, you know
Well,
what?
take pictures and post it on
Yeah.
Facebook.
Of your hotel room.
Yeah,
at least.
Yeah.
I'll put some pictures up there, but I don't know
Yeah.
how interesting it's going to be. The same picture, different times of day.
Here's the
having
sun. Look across my-
having lived there, I still am jealous. So
Oh, you live there? Oh, wow.
yeah, I went to high school there. So
Oh, do you speak Japanese?
Skoshi,
Ah,
Ikor deska, like how much is it? That's really what I took French. So
I was going to say I could certainly use an interpreter. I might be emailing you going, hey, what is I don't know.
I found when we were in Japan, we were with football, the one common thing was numbers. So they would put things into a calculator and then show us the calculator so we'd know how much we had to pay. And that was
Yeah.
like, most stores are people that spoke English, but like in the neighborhoods, that was the only way anybody interacted with, like, here's your number.
Mhm.
So it worked.
yeah. Well, safe
Yeah.
travels. I got to
Yes.
hop on another
Thank
call,
you.
but thank you again. Thank you both. I really
Oh,
appreciate
Yeah, it
you
was fun.
You.
accommodating
Appreciate
this VOE. I just think when we do the podcast, it's important to kind of
Yeah.
put that
No,
discussion
honestly,
out
it's
there.
good to
So
talk about, so it was good.
yeah.
And good PR to get some members, Allison.
Yeah.
Hopefully we will.
We try.
right.
All right.
All right. Safe
Sounds
travels.
good.
Have a
Matt.
good
Have
one.
fun.
Bye-bye.
Bye.
Bye.